G'day once again. We're going to dive a little bit deeper into the murky depths of the courtroom and what they're doing. Some of you out there still insist on going to court, so you're getting yourselves into all sorts of problems. So hopefully this will get you a bit further. You'll have a bit more understanding, and you'll be able to see what game they're playing, and you'll have a bit more confidence in dealing with the judges and the corrupt officials that run the place. So let's first look at the roles of the players there. The role of the judge first. Now, he can only hear argument. The judge is like a glove puppet where you have to stick your hand into the glove and wiggle it yourself. The judge can only hear argument. If he does not hear argument, he has nothing to arbitrate on. So he arbitrates between the parties who have an argument. That is his sole role. Well, supposedly. He will, as you'll see a little bit later, try and do things differently. But that is his sole role. He is the arbitrator between the two parties. Now, the role of the court. Let's have a look at the role of the court. Oh dear, that's exactly what it is, folks. That's where all the money gets generated, at the bank. It is a bank, and he makes sure, the judge makes sure that everyone gets paid who comes into his court. Now, the role of the prosecutor. Oops, slip of the tongue there. Prosecutor. The prosecutor takes a gamble that we do not know who we are and that we do not know our rights. And he does this in the hope of gaining a commission, because if we don't know our rights, he will get paid. So let's now look at how the process works, because you can see it's stacked against you right from the start. They're all in this little club together. So someone lays a complaint with the police, or you get pulled over for a traffic ticket or whatever. This is what's going to happen. An information is going to be written up and signed by the informant. Someone has to lay a complaint. Now, the information then gets served on us, asking us to answer the information. Answer will become a bit clearer later on. Some of these things will become a bit clearer later on. So it's up to us now. We can hire a lawyer or do nothing. And then we will get an invitation or summoned to appear in court. Okay. The information. An accusation exhibited, this is from Black's Law Dictionary, the 5th edition, and I have to thank the trained professional for providing me with a copy of this. The information is an accusation exhibited against a person for some criminal offence without an indictment. An accusation in the nature of an indictment, so it's not an indictment, but it looks like an indictment, from which it differs only in being presented by a competent public officer on his oath of office. So it's only on his word, instead of a grand jury on their oath. So what they've done is they've short-circuited the system here, and instead of putting it before a grand jury on their oath, they have a competent public officer do it. Now, it's a written accusation made by a public prosecutor without the intervention of a grand jury. Tells you there. In most states, the information may be used in the place of a grand jury indictment. There you go. Indictment. An accusation in writing found and presented by a grand jury. There you go. Convoked and sworn to the court in which it is impaneled, charging that person therein named has done some act or been guilty of some omission, which by law is a public offence, punishable on indictment. A formal written accusation originating with a prosecutor and issued by a grand jury against a party charged with a crime. An indictment is referred to as a true bill. Oh dear, I told you the court was a bank. It's a true bill. Whereas failure to indict is called a no bill. An indictment is merely a charge, there we go, everything's about money, which must be proved at trial beyond a reasonable doubt before defendant may be convicted. So there you go. It's all about money, folks. Okay, let's look a bit further. Now let's look at an answer. So they've served an information on us, asking us to answer the information. And the answer is a pleading in equity, a defense in writing. Now be very careful, because this is what we use to avoid going to court. So if you get this part of it right, you won't need to go to court. Okay, a defense in writing made by a defendant. We'll talk about defendant later. To the charges contained in a bill or information filed by the plaintiff against him in a court of equity. The word in answer involves a double sense. Okay, so it's two things. It is one thing when it simply replies to a question, another when it meets a charge. The answer in equity includes both senses and may be divided into an examination and a defense. In that part, which consists of an examination, a direct and full answer or reply must in general be given to every question asked. Okay, so what they're telling you here is that when you respond to the answer, you must do it in two parts. So the first part, or the reply, must be given to every question asked, and the second part, in that part which consists of a defense, the defendant must state his case distinctly, but it was not required to give information respecting the proofs that are to maintain it. Okay, so the first part, you do answer to the charges. I'll cover this in another one a little bit deeper. Okay, in substance, the answer ought to contain first a statement of facts and not arguments. So you state the facts. Second, a confession and avoidance or traverse and denial of the material parts of the bill. Its language ought to be direct and without evasion. For an historical account of this instrument, see Barton's History on Treatise of a Suit in Equity. Okay, answer as a verb, the word denotes an assumption of liability as to answer for the debt or default of another. Okay, the first part is from Bouvier's. This last part here is from Black's 5th edition. Okay, so we're slowly going through all the different words here. Now let's get to lawyer. When we hire a lawyer, they then represent us. But what this really means is that they represent us as the corporation. Okay, so they don't present us as the true living man, they represent us as the corporation. Now let's look at how they trick us into believing that we are the person named on the charge sheet. Okay, so here's how it happens, you see. Everyone should have got a birth certificate, and it'll have this sort of information on it. It'll have, number one, it'll have John Henry, which were your given names. Number two, it'll have a surname, Doe. Then it'll have the sex, which is male, the date of birth, the place of birth, etc. Now, conversely, here in New Zealand, we have a printout. In America, you have your certificate of live birth. In Australia and England, you have your extract. But the printout is the proof of when we were born. Now, notice the difference, born and birth. Okay, so born on the 3rd of the 3rd, 2000. Where born? Auckland. Given names, John Henry. Informant. Now, we've already seen what an information is, so whoever lays the information is an informant, so they're laying a charge. The informant is John Henry Doe Sr. The mother is Jane. Now, if you notice there, when you were born, you were only given two names. You were not given a surname. That is the living person. That is the dead one. Okay, so let's dive a little bit deeper into this. The printout is a copy of what is contained in the register. It shows when we were born, where we were born, and shows that the only names that were given, such as John Henry, this is the living, breathing man. Okay? This is proof that you were born and that you are living. The birth certificate, conversely, this is an estate which was created when your parents registered your born details. The estate also established a sedicay via trust in the name of the Father. This is merely a warehouse keeper's receipt for the property that the bailee in possession holds on our behalf. They had to give us a receipt to tell us they're holding our property. Estate, the degree, quantity, nature, and extent of interest which a person has in real property. An estate in lands, tenements, and hereditaments signifies such interest as the tenant has therein. They're telling you we are only the tenant while they're holding our property. The condition or circumstances in which the owner stands with regard to his property is contained in a court case, Boyd versus Sibbald. Look that up yourselves. In this sense, estate is commonly used in conveyances. Okay, so when they conveyed the title to our property, that's what they're telling us there. The words right, title, and interest, and is in great degree synonymous with them all. Okay, so when you see a conveyance or property or estate, you know that rights, all our rights, title, and interest are held by them. Okay, the birth certificate is also a corporation. Once again, thanks to the trained professional, we've now got Black's Fifth Law Dictionary, and we have a look what a corporation is. It's an artificial person or a legal entity created by or under the authority of the laws of a state or nation, composed in some rare instances of a single person and his successors, being the incumbents of a particular office, but ordinarily consisting of an association of numerous individuals. Okay, so what they're telling us there is that you can have a corporation with numerous other people, but it's also an artificial person, which is what they have done to us. We are an artificial person or a legal entity. And so a corporation can trade, and the corporation is the one that goes to court. Corpse. This is where corporation comes from. Corpse, the dead body of a human being. As a corpse is considered as nullius bonus, or the property of no one, oh dear, it follows that stealing it is not at common law and larceny. So they can steal what they like because we're dead, and they can only deal with dead. And corpus, once again, corpse, corpus, corporation, all from the same word, a Latin word which signifies body. As corpus delicti, the body of the offence, the essence of the crime. Corpus juris canonis, the body of the canon law. Corpus juris civilis, the body of the civil law. Okay, so you can see that these people can only deal with the dead, and as it's the property of no one, dead bodies belong to no one, it follows that stealing it is not an offence. What a wonderful system. Okay, corporations. Now, this one's from Bovier's Online Law Dictionary. Very easy to get that one, guys. Just go up online and type in Bovier's into Google and you'll get this. Name. Now, we're looking at the name. So, we're also a name. We've received a name by getting our birth certificate, which is one or more words used to distinguish a particular individual. Okay, but the one that we're interested in here is number 5. Now, there's a whole heap. I've missed all those out because the one that we're really interested in here is number 5. In general, a corporation must contract and sue and be sued by its corporate name. Okay? Yet a slight alteration in stating the name is unimportant if there is no possibility of mistaking the identity of the corporation suing. Now, what they're telling us there is that only corporations go to court. A corporation must contract and sue and be sued by its corporate name, and that's why, as a corporation, we get dragged into court if we don't know who we are or what we are. Okay, so the estate, the name, the corporation is also, oops, did I go backwards there? Sorry. The crown. I have revealed this before, but the estate, the name, and the corporation is also the crown. Now, this is where not many people have realized this up to date, but this is how the process works. Someone lays a complaint with the police. Information is written up and signed by the informant. In minor cases, the police prosecutor will present the case to the court. Criminal cases will be sold to a private law firm, normally called the Crown Prosecutors or the Crown Law Office, or something similar. But for those of you that still insist on going to court, we need to know the roles of the parties in establishing our standing. So let's look a little bit deeper. As I said, the police will sell this to the prosecutor. So the prosecutor will have to proceed summarily under the Summary Proceedings Act 1957. To proceed summarily, the prosecutor must come in under Section 49 of the District Courts Act. And this is what this says. Trustees, executors, and administrators. Any trustee, executor, or administrator may sue and be sued in a court in like manner as if he were a party in his own right, without joining any of the parties beneficially interested in the trust or estate. And you know that we are an estate and we're a trust, a Sedekah trust, and shall be considered as representing such parties in the proceeding. There you go. He's representing the parties. The court may at any stage of the proceedings order any of such parties to be made parties to the proceeding, either in addition to or in lieu of the previously existing parties thereto. Now, we've also read earlier on that they may proceed on information alone. So the information does give them the right, but it's written there in the Act how they're doing it. So although you know that they can proceed under an information, you can see under the Summary Proceedings Act how they proceed summarily. Now, all the prosecutor needs to do is to trick us into believing that we are the corporation that was called, and he has an adhesion contract by joinder. And this is what they're going to try and do to us. He will do this by telling the judge that he is there on behalf of the Crown. Now, we've already seen who the Crown is. The judge will then assume that we are the defendant. Once again, Black's Law, 5th edition, defendant. The person defending or denying, the party against whom relief is sought in an action or suit of the accused in a criminal case, okay? That's the party who they're trying to get relief from, the defendant, not us, from the defendant. Because if we know who we are, we certainly do not want to be the defendant. We want to be ourselves. And so defender is to answer for, to be responsible for. We do not want to be responsible for that debt. No way. We want to be ourselves. So here's what normally happens is the judge gets handed a folder by the registrar and he calls the corporation's name. We mistakenly believe, well, all our lives we've been told that that is our name, so we believe that that name is us and jump up to acknowledge the judge. Judge now has an adhesion contract between the living and the dead, because he called out a dead person and anyone can claim the dead person's property and it's not an offence. But if we do it this way, when the judge calls out the corporation's name, we jump up and say to the judge, I'm here about that matter. Things could change, because now the judge will ask, are you Mr. Doe? Once again, they have to add Mr. because the Doe being in all capitals. Now, here's a little trick that they use. If they use Mr., they do not have to capitalize it, because that's a rank. If they call you, they must use Mr. because you cannot see the capitalization in their voice. All you can hear is the Doe, and you don't know whether it's all caps or upper and lowercase. So therefore they add Mr., which is demeaning. Okay, we must now establish our court by asking the judge, Your Honour, before we go there, I must ask the prosecution a question. Now, he's not going to like this, because he knows that if we're going to start asking the prosecutor doesn't know all the rules that the judge does. So do not ask for permission or wait for a response. Just go ahead and ask the prosecutor whatever you want to ask him. Now, the judge will try and deny you this, and you must object. Every time he tries to interfere, you must object. Just say, objection, Your Honour. I am asking the prosecutor a question, and go ahead and ask. And so this is, you can ask the prosecutor a number of questions. This is just one that I would ask. Mr. Prosecutor, are you here on behalf of the Crown? Now, we learned what the Crown is, so how do you think he's going to respond? So he's going to say, yes. But as you know who the Crown is, you can say, thank you, Mr. Prosecutor. As the only one with clean hands and equity that can answer on behalf of that Crown Trust, I now order you to pay all the charges. You see, if you know who you are, you can order him to pay the charges. And he does. He has to get out his checkbook. Trust me. But you're going to have to beware of the traps, because all the court officials know the rules and will all play the game to intimidate us, threaten us, and coerce us into playing their game. If we don't, they have to pay, and they don't like paying. They want us to pay. The moment that we stand up to the judge, he pushes a button with his foot that alerts all the court staff. Now, the lawyers in the court will all turn around and they will mock us and try and intimidate us. They'll all laugh and go, ha, 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 what's he on? Rah, rah, rah. They all know the games. And I was told this by a lawyer, because after he passed his, he was a mate of mine, and after he passed all his bar exams, he had to go and sit for 6 weeks and learn all the details of how to talk to the judge without us knowing that they were passing coded messages, and how to, how to run the court properly. Okay, now the next thing that will happen is that the security and police will rush into the court and stand real close to us, trying to intimidate us. They come in and they must try and intimidate us, because they must get us to back down. Otherwise, they're going to get found out. So they all play the game. Now, you've got 3 shots. And in most cases, the first time you question or refuse to contract with the judge, he will be polite and answer your question, not knowing how far we're going to go. But the second time is when he pushes the button and raises his voice to you and starts to get really nasty towards you. The third time he gets really angry and he yells at you, and by this time all the court officials are all staring at you, intimidating you, and the cops and the security are there giving you a real hard time. Stand your ground, because if you rebut him for the third time, he must vacate the bench. They only get 3 shots, and he must walk out of the bench. And I've had this happen many, many times when I've been in court for myself or for acting for other people. The judge has hopped up and left the court. Back then, I didn't really know what I was doing. I got myself into a lot of trouble. But however, now I do. And here it is, all contained in these 10 commercial maxims. Go online, type into Google the 10 commercial maxims at law, and learn them, okay? Some of them give you the explanations and the Bible references, and when you know these, this is how all commerce operates. Okay, a workman is worthy of his hire. All are equal under the law. In commerce, truth is sovereign. Truth is expressed by means of an affidavit. An unrebutted affidavit stands as the truth in commerce. An unrebutted affidavit becomes the judgment in commerce. A matter must be expressed to be resolved. He who leaves the field of battle first loses by default. Sacrifice is the measure of credibility. A lien or claim can be satisfied only through rebuttal by counter affidavit, point for point, resolution by jury, or payment. Okay, so let's look at the most important ones here when we're in court. 2, all are equal under the law. Now, what I said to you earlier was that you must establish your court. Now, if the judge is equal with you, why can't you establish your own court? The only reason you don't is because you don't know that you are able to establish your own court. Okay, the judge is equal with you, and if you get in first and establish your court and do not give him any standing, then your court prevails. Okay, now what I told you in the previous slide was that the judge will vacate after 3 attempts. So he who leaves the field of battle first loses by default. The reason he's leaving is that he has had 3 shots and now he has lost the battle, so he leaves the field of battle. Now this is where these are the ones that we did not know, and so the next part, which is the most important, a matter must be expressed to be resolved. So at this stage you must say, the judge has left the field of battle and loses by default. I now dismiss all charges. Okay, now you have notified them that the judge has left the field of battle, so he's lost, and you have expressed what you want done. They must follow suit. It's that simple. There are many more traps, and these are just a few of them, because I'm trying to keep these videos short. But just remember that the moment you ask the judge for anything, you have conceded your sovereign status. Okay? Do not give him anything. He will then establish his court. And if you don't ask, you will not get it. Hope this helps, and you have a bit more standing in court from here on.